started. I'm Vogl. This is Legal Informatics, Law 729, CS204, listed course. I'll be co-teaching this class with Professor Genesereth from the Computer Science Department. Professor Genesereth directors of Codex. Codex is the Stanford Center for Legal Informatics. And it's a joint center between the Law School and the Computer Science Department with the mission to do research and develop technologies that improve the legal system. So, so virtually no day goes by that we don't hear about how the legal profession is changing and how the legal services industry is evolving rapidly, and much of that change is really driven by technology. And come on in. Yeah, that's terrible there. So, so technology is really coming from all sides, and until recently there was a sense that technology would really only affect sort of the low-level legal work. Only kind of low-level legal work would be commoditized by technology, and big law and students who are sort of preparing for a career in big law would not really be affected by the change. But in recent years, it's sort of become clear that big law needs to change too, and big law is in fact embracing this change. And folks who are going to law school now are going to graduate into a very different legal market than the folks who are out there now. So the bad news is that the things have already started to change, and the good news is that that's a huge opportunity for you all taking this class, and for folks who have creative ideas to shape the future of the law and the legal system, and you know, improve the way things are done, and there will be plenty of opportunities to monetize this kind of creativity. The good news is also that this place here has brought out a lot of the folks that I think are sort of leading the pack of disruptive innovators in the space. So we've been called the vortex of legal technology by the media, and you know, it's been lots of graduates from this law school who are really doing some really exciting work, and many of them are actually going to come and join us for this class. So this course is really at the forefront of this technology-driven change in the legal system, and we have a really amazing lineup of some of the country's leading experts and innovators in the space, as you know, coming as guest lecturers, and they'll be sort of sharing their ideas and viewpoints with us, and so you'll be exposed to really you know, a ton of different ideas, and in order to sort of keep some kind of organization of what's going on in the space, we have, you know, as we've been observing the space for some time, we've developed this kind of framework of basically different approaches to solving legal information problems. And so we've kind of created these three different buckets. You know, first one being legal document management, second one being legal infrastructure, the third one being computational law. And so what do we mean by that? So legal document management is basically concerned with the creation and retrieval of legal documents. So the computer really doesn't understand the content of the documents, but it can help get to the document. And so, you know, those documents can be statutes or laws or patents and what have you. Legal research technology, which we're going to be talking about today, is really, you know, the legal technology that law students are confronted with first. And that's, you know, a good example for a legal document management system. But also, you know, the whole space of e-discovery is an example for legal document management. So e-discovery, oh hey, sorry, only standing room only.
We got one seat back there.
There's one seat back here. So, so the whole e-discovery industry is about a $50 billion industry in the U.S. And you know, sort of if there are ways to automate the retrieval of documents in e-discovery, that can actually create a lot of value. So next, we have legal infrastructure. So by sort of technologies that we sort of categorize on legal infrastructure technologies, we're thinking about systems that help basically connect the different stakeholders in the legal system more efficiently. And so, an example of a new legal infrastructure project would be these online marketplaces for legal professionals, right? So those are technologies that help stakeholders in the legal system connect more efficiently. And then last but not least is computational law. And so computational law is basically an innovative approach to legal informatics, which is based on the explicit representation of laws in computable form. So basically those are systems where the computer can understand legal meaning and engage in a certain amount of legal decision making. And one sort of sub-form of that is what we call embedded law. So that's where the legal information is brought as closely to the human decision making as possible. So what's an example for a computational law system that actually many of you might be using in the coming weeks, or you have just used? Anyone?
TurboTax?
TurboTax, yeah. TurboTax is a system that that can actually execute legal decisions. So you add certain facts about your life into the system, and ultimately the system tells you what your tax liability is, which is a legal decision, right? So, okay, so we want you to think about everything you hear in this kind of framework, and we've also, because we think that makes a lot of sense, it helps you organize, a very vastly expanding field of legal technology. And so we've also organized this class following this kind of framework. So we have classes, 3 modules, and we're starting out with legal document management. So the first 3 weeks will be dedicated to technologies that can be categorized as legal document management technologies. We'll be starting out with legal research technology with Paul Lomio today and Pablo Arredondo. And next week we'll be talking about data-driven law practice. Then in week 3 we'll talk about the consumer law revolution. And that's going to be leading us into legal infrastructure, module 2. We start with legal lead generation technologies. Week 5 will be on legal service, breaking legal services into business processes, which is where sort of a lot of these new players really are, and sort of figuring out how these legal processes can be broken into subparts and made more efficient with the use of technology. Week 6 will be dedicated to access to justice. And then we'll be entering module 3 by week 7, where we're going to start talking about computational law. week 8 will be dedicated to computable contracts, and then final week 9, will be dedicated to legal ethics and the unauthorized practice of law rules and how they affect sort of these new technologies that are out there that can actually provide legal services to a certain degree what traditionally has been reserved for lawyers. Okay, let's talk about some of the logistics of the course. So, in order to get a grade for this class, you have various options. So, option number 1 is the Legal Technology Project. So, we have asked various friends of Codex, which are some very large companies, some mid-sized companies, and some very small startups, to share with us some of the research problems that they have on their mind, and sort of present them to the class and invite the class to work on one of those research problems. So those are real-world legal technology research problems, and we can put them up on the coursework page. The companies that have submitted research problems include large players like Thomson Reuters, so mid-sized players like Legal Force, and smaller companies like CaseText, which we're going to hear about today, Law Gives, and Fair Document. And so take a look at those problems and see if something speaks to you and you want to work on that project. The deliverable for the technology project is a research report, or you can also there's a chair back there. Or you can also build a little prototype if you want. You can work on these projects by yourself, or you can create a team of some of your classmates and work together on a project, which is probably a really good idea. So you don't have to pick one of those problems. You can actually define your own problem. If you have an idea for a legal technology project you want to work on, by all means you should do that. Please also let us know by week 3, what the project is you'd like to work on. So this is option 1, and I think by default you're all signed up for option 1. You can also write, as an alternative, an independent research paper. Also, please by week 3 let us know the topic you want to work on, and then we'll set up a time and we'll meet and talk about your research project. If you choose option 2, you have you can actually get 2 credits or 3 credits, depending on how long the paper is. And yeah, I think for 3 credits, to get 3 credits, it has to be a 26-page paper. And then also part of the grade is class participation. We want this class to be as interactive as possible. We also ask people to sign up at least once per quarter to be a commentator. And that means you come to class having read all the materials. Obviously, we want everyone to read all the materials, at least the assigned materials. But the person who's a commentator will be asking and sort of leading the first couple of questions and commenting on one of the assigned papers. So please also send me an email, let me know which of the upcoming sessions is of most interest to you. You want to sign up as a commentator. Okay, so let's talk about the schedule. So we have, as I said, we have really a terrific group of guest speakers coming in, from all around the country, really the leading thinkers and innovators in the space, and so this is going to be really, really exciting. Because there's so many people coming to this class, it's possible that we may have to make some kind of last-minute changes because somebody might ultimately might miss a plane or whatever is going to happen. Also, with regard to the readings, we have a list of assigned readings and a list of optional readings. It's possible that some of our guest lecturers will, sort of give us some additional readings or assignments in the sort of week before class. I will distribute the readings as soon as I have them. But if you go on the coursework side, you will see that there's already, for each class, we have already a good number of relevant readings assigned. Okay. Just before we start with this class, there's also just wanted to make two quick announcements. So this quarter, there's a lot of interesting stuff going on in legal technology here at the law school. First event I just want to point out is a Codex Speaker Series event with Professor Rodi, who will be talking about innovating within the professional monopoly, the law of unauthorized practice meets the technology boom. That's on April 17th, so it's just before our class meeting, and lunch will be served. And so that's already a little bit of a kind of foreshadowing of our deeper session and on the unauthorized practice of law, which is our week 9 session, where we're also going to have, actually we're going to have the chair of the e-lawyering task force at the ABA join us, Mark Lawrence. And we'll have some startup folks who will tell us exactly how they designed their system to operate in this legal framework. Also, we have a big conference coming up, the Codex Future Law Conference. That's on May 2nd. Students taking this class can register for free. Please use class 2 as your registration code. And this way you can get it for free. And that's, this is also going to be a very important event, and I hope that you can all attend the event. Okay, so are there any questions regarding the logistics before we go and start with the session? Any other questions? Okay, so then let's get started.
Before we get started?
Yeah, Professor Genesereth.
Computer science students, are there any computer science students in the room? Okay, so you guys are welcome to do just exactly what Roland said, but we would hope that anybody in computer science might lean more toward the technology end of the spectrum and possibly do some technology work. And we'd also like to suggest that it may be good, it's certainly acceptable and may even be desirable to consider working together with other people if you'd like. So maybe a law student and a computer science student teaming up is a great thing. So that's not to be argued against. We want that. We'd like to see that happen. It's okay if you want to make that happen. If you want to work by yourself, of course, it's fine. But a pairing of somebody from law and somebody from computer science is really good. We would really like to see that happen if at all possible.
Great. Thank you. Okay, so our first session today is legal research technology, the past, the present, and the future. And it's a real pleasure to have Paul Lomio as our guest today. Paul is the head librarian here at the law school. He's also a lecturer here at the law school. He's been teaching advanced legal research for many years. He's published a ton of important works on the issue, and he has seen a lot of the evolution of the space firsthand, and so it's a real pleasure to have Paul here. Paul will be taking over from here, but then we'll have Pablo Arredondo from Case Text, which is one of the really interesting and exciting new startups in the legal research technology space, speak to us. So yeah, Paul, over to you.
Can you start the PowerPoint?
Sure.
Thank you for having me here.
It's great to have you. So,
great. So I started today with the Constitution, and I brought copies of the Constitution. I didn't bring enough, so if you didn't get a copy of the Constitution, want your very own copy, come see me. I bought it particularly for the non-law students who may not have the copies already, but it starts with the Constitution. And also I want you to think about, or you think of the clauses in the Constitution dealing with due process, equal protection, when we talk in this class about how information is packaged, how it's sold. And then the Constitution also sets out these three branches of government. Each one of these produces laws: the legislative, the executive, and the judicial. And tools for legal research. Legislature produces statutes, and these are compiled in codes. And have any of you heard of Chapter 11? You might have heard of it in newspapers, right? What's Chapter, you're nodding, what's Chapter 11?
Bankruptcy?
Chapter 11 is a reorganization law for bankruptcy, that's right. And it's published in the US Code. And this is Chapter 11. This, just this, that's it. You could read the code, the US Code, cover to cover, without any difficulty. And you can certainly read Chapter 11 without any difficulty. The problem comes when you try to understand the code. And this is intentional, because as a process of compromise, things are left vague, unanswered in the code. There's one section here, who may file a claim, section 1121. May seem straightforward. I shepherdized that one section. There's 2,144 cases interpreting that particular section, published cases interpreting that particular section of the code. The lawmakers use words, and they know that they have to use these words in order to get a compromise, and they know that the courts are going to hash out the details later on. You'll see words like reasonable in the code, right? The Americans with Disabilities Act says that employers have to make a reasonable accommodation. They don't tell you what that is, okay? There are hundreds, if not thousands, of court decisions. So it's really important to get these court decisions. And having the code's available online, it's free, it's widely available. The same thing for administrative law, that code is also online, free, up to date, available worldwide, and you can also read it cover to cover. What you can't read cover to cover are all of the cases. There are, by 2000, there were 5.2 million published cases, and that's just published. There's also this whole other part of the iceberg of unpublished cases. And 100,000 cases are being added annually. So case law research is important. And back when I was in law school, the only electronic technology we had was this. For those of you who don't know, it's a photocopy. So how did we find cases? The technology we used was this. And this is called the digest. It's a digest system. It's a product of the West Publishing Company. And it traces back to 1876. When John and Horatio West, neither were lawyers, created this company because lawyers have to know the law. Okay, and all judges do is make decisions and write opinions. Okay, they don't publish those opinions, they don't disseminate them, they don't make sure lawyers get them, they just write them. But the lawyers have to know what's in those opinions. They have to be able to find the law. And so John was a salesman of law books, and he saw the frustration that lawyers had, not keeping up with what's going on in the courts. So he started this system, West Publishing Company, and he created the digest, which is really the index to case law. And the way it works, well, first he had to get the opinions. And so he went about, and there's a little article that I gave to Roland, I don't know if you guys got it or not, but it's an interesting one about how West began to woo the judiciary. They would ask judges for their opinions, they would give them, the Royal Law Book Company, they would give them free books, they would kind of appeal to the judge's ego by compiling the opinions of a certain judge, binding it, putting on the spine the compiled opinions of Judge Roland Vogl, give it to the judge. They had a person whose sole job was to try to make judges happy. They sent people to every judicial conference they could go to, and it worked. They got judges to send them their opinions. And so what happens when the opinion gets sent to West? Well, two things happen. First, a general editor looks at the opinion, okay? And this general editor will read the opinion, look if there's any errors, and then we'll get back to the court and say, hey, we see that you have this, is that an error? If the judge said yes, they will correct it. If the judge says no, then they leave it exactly as it is. They will write a summary of the opinion called a synopsis. And this is actually really, really helpful because you may have an opinion involving a child, and think of all the words that could be used by a judge to talk about the facts. You could say child, you could say minor, you could say juvenile, you could just say 14-year-old. And so what West did was come up with a topic for all of those different situations called infants. That may not seem intuitive, that a 16-year-old will be an infant, but that's where they put it in the topic. So that's part of this process of trying to index the law. So the general editors, they had to be lawyers, they had to be a member of the bar, and their job was to first check the opinion for possible errors, put in citations, complete citations to statutes or codes. They also would write the headnotes. So what the headnotes are little pithy summaries of points of law contained in the opinion. So for every opinion, there may be 1, there may be 20 points of law, and they would try to distill that into a little summary called a headnote. Okay. So editors would do this for 10 to 15 years at West before they could be promoted to classification editors. Okay. And classification editors are the people who then went and assigned those points of law to this big, broad system of general topics, 400 topics, and 100,000 subtopics in their effort to index the law. And they're all in this book here if you want to take a look at it. All the topics and subtopics are listed here. So this is a tool that we use to find cases for 100 years, from 1876 to 1976. Until the advent of computer-assisted legal research. This is our first contract with Lexus. We signed it in October of 1976. Here it is, our very first contract. Lexus was first. It was first came out in 1973. Sherman and Sterling, a New York City law firm, was the first customer. It started with Ohio and New York code and cases. Ohio because it started as a project of the Ohio Bar Association, actually, to get started. So we had Lexus in the library. We could not access it between 11 a.m. and 2 p.m. Monday through Friday. Any guesses why that? Phil, any guesses why that might have been?
I have no idea. That seems super arbitrary.
Well, at 11 o'clock to 2 o'clock here is 2 o'clock to 5 o'clock on the East Coast. Okay?
Okay.
All the lawyers were, in New York City, and Lexus was afraid that we would just bring the system down, and they were trying to get their cases done for the day, so we could not access it between these restricted hours. This was a terminal that we had. It's called the Lexus Deluxe terminal. It was a phone line, and it had these idiot-proof buttons, like a big button, like that one, that says next page, and next document. And they were trying to appeal to lawyers who didn't know much about technology. And back in the day, lawyers didn't even type. Their secretaries did the typing for them. So this was a pretty new way to access information. By 1979, they were up to 1,200 baud modem. The only other terminal we had at that time was this one. This one we used to access dialogue. Have you heard of dialogue databases? It's now ProQuest. It's a company here in Palo Alto, I think, started. And so we would pick up the phone, dial the dialogue number, stick the phone in the mouse ears, and then type our search and access. There was quite a bit of legal information in the database back then. patent information primarily and indexed to legal periodicals. So we did actually use it, but mainly for non-law materials. People who were researching things, law and something. So Westlaw was a little slow in the marketplace. They came out in 1975, but for various reasons, they made a really big misstep when they first came out, and that we only put the headnotes online. They didn't put the opinions online. And there's various reasons for that. One, they're extremely proud of it's their magnum opus, this digest system. They're very proud of that, but also, they didn't quite get it. And there was competition within the company. They had the print and the electronic, and they were afraid that, sales of the electronic would affect the books, and they just didn't see what lawyers and academics wanted. They didn't want somebody else's words. They wanted the words of the judges, but it wasn't there. You had to use it as an index. It was an automated digest to then go find the opinion in a book to see what the actual law is. But they also use these Boolean connectors, the Boolean buttons, and, but not, same paragraph, same sentence, preceding same sentence. And they call this the Walt terminal. Let's see. I think I wrote down what that stood for. They had a contest. Reference librarian here at Stanford won it, named it Walt, Joan Howland. West automated, I forget, I'm sorry, I don't have that. I meant to put that. So what happened was, Westlaw initially was a failure, a market failure, and Lexus sales by '87 outpaced Westlaw's by 9-1. Lexus was the company. Westlaw, of course, saw the errors of their ways, and in 1978 they went full text. So this is our computer room in the mid-'80s, and we no longer had, well, they were dedicated terminals, but Lexus and Westlaw provided these terminals to us. They provided the printers, they provided the paper, they paid for the phone lines. Each one of these had a telephone, and they provided the phone lines. We had to go through our monthly bill, highlight the ones for Lexus, mail it to them. They would then give us a check for phone lines. They also gave us communication software. We were the first law school to give students communication software. And so we had these boxes in the back of the room, big plastic boxes, one set for Westlaw software, one set for Lexus software. Lexus was the first to do that, and they usually when one does something, the other quickly follows. And they tried it with us first. Again, their concern was the heavy use by students would bring down their system. So they wanted to test the waters, and Stanford was a place where that happened. They didn't go it wasn't web-based until 1997. So we had the telephone, all these telephone lines and reimbursement going on until then. So how did the searching work? Well, we had to do Boolean searching. And you had to also select your library, select a file, what they call the library, a file, and do your search. So if I was looking for district court cases and charter schools, the search might look something like this. I would first select the library, Gen Ed. I would then select the file, district courts, and I would then do a Boolean search here, the word charter, within 2 words of the word school, but I misspelled school, and I make typos all the time. And I actually did this once, and one case came back, because there was one case with the same typo. But these typos can be expensive. Each time you hit search, well, there's 2 ways to pay, 2+ ways to pay for Lexus and Westlaw. One is by transaction, which is each time you push the enter key, you're charged a transaction fee. The other is by per minute charges, which every time you're on, every minute you're on, you're being charged. And depending what you want to do, you want to choose a certain one. I mean, if you're going to be reading online for hours, then a transaction would be the way to go. If you just want to go in and out quickly, would get something then per minute. So there's some some strategy involved with how to bill, and law firms would work with the new associates to help them figure it out. But it was very expensive. I mean, that typo, if I was searching all federal and state cases, that one typo could have cost me $194. They'd have to go back and do another search, spelling it correctly. So expensive, very expensive. In addition, firms, everything is negotiable, and firms will pay flat fees for Lexus or Westlaw, or at least flat fees for certain content. And then things outside of the plan are charged at these rates. And those contracts are confidential, so I don't know how much firms are paying. But it's not insubstantial by any means, and they base it on how much you use it. So a lot of heavy use of Lexus and Westlaw will cause next year's bill to be a little larger. I'm getting ahead of myself just a little bit. So the big development one of the big developments in both Lexus and Westlaw was natural language searching. So in 1992, Westlaw was out the gate first with what they called WIN, W-I-N, Westlaw is natural. And then in 1993, Lexus quickly followed suit with something they call LINK, and I couldn't find out what LINK stood for. I did a quick search this morning, but I couldn't find it. But there was no natural language searching. And this has definitely took off. I mean, you guys, you law students, you only use natural language, right? Right? I mean, who uses Boolean here? A little bit? But mostly natural language, right? It's job security for us. We used to like teaching Boolean, but now it's all natural language. So then Westlaw Next is the next big thing. And that's what we have right now. And again, Westlaw was first with Westlaw Next. And Lexus has their product Lexus Advance, which is still being fixed. It's not perfect. But as you can see, Westlaw Next, they use what they call a West Search. And it draws on the editorial enhancements. Okay? It draws on this key number system, part of the National Reporter system. And it does seem to produce good results because of that. It also draws on what people are using. They look to see what lawyers, mainly lawyers, are, what cases they're looking at, what cases they're downloading, and they factor that into the search. They don't look at what law students are doing. So only lawyers. And the Westlaw Next, it's really amazing because you don't have to worry about knowing libraries or files or Boolean or anything else. You only have to know two things. Thing one, what's your jurisdiction? Okay, say you want to search for California federal cases. You select, first step, select your jurisdiction. Second step, just type in, like it says, anything. Just type in what your search is. And then it will search all of this stuff, these two columns here. And it will give you a result with cases, statutes, regulations, and the rest of these things. The case result is very strong. It's very good for finding cases and statutes. It kind of breaks down at the regulations level. The regulations seem to make no sense at all often. And I think it's because there's no human content behind those. Nobody's indexing them. Nobody is assigning language to them, descriptors to them. And the computer just doesn't seem to be able to find the relevant regulations. So the billing is,
Paul,
yeah.
Come back to that second. Can you say a little bit about how that works, or how you believe that works? Is it doing a search of the full text of the documents? Is it the headnotes? Is it the keywords, the classification? How is it doing it?
Yeah, I think all of the above. I think it's doing everything. So, and in particular, I think it's emphasizing the indexing. I think, but I'm not exactly sure.
So if I were to use Google on their database, what would have been the difference? Is there something in addition to what Google does that it provides, other than, given that with all this extra information that's been added?
Would they factor in they have other customers
Jurisdiction
who's using stuff. So, and this is the pricing at $99 per search, plus whatever the subscription is. But I also want to point out secondary law. So primary law, secondary law. Okay. Primary law is statutes, cases, regulations. Okay, the actual law. Secondary law are materials that explain it. It's oftentimes it's like what you might read in a treatise. It's an authority, and it's expensive. And people really need or really want that analysis. They want to know what somebody who is an authority in a subject area has said about a subset of cases. The fact that somebody who follows privacy law very closely has identified the leading cases in that area means something, and it's worth something. And that's why it's being charged. Lexus is a little cheaper, but it's similar pricing. Again, same thing, document access charges. Secondary law is more expensive than primary law.
What are the litigation materials? Oh,
Yeah, litigation materials.
those are on the previous slide.
Litigation materials. I'm not exactly sure what those are. Maybe briefs, maybe, or court records. They do have not available to us law students, but they do have transcripts, video and print of trials. That might be what they're talking about here. So Chris Walker is a student, was a student here at Stanford. He was in the advanced legal research class. He's really an outstanding student. He was really one of the top students I've ever seen here. And so I followed him on Twitter. And when I saw this tweet from Chris, just annotated my first case on case text, such a cool and free legal research and discussion tool, I was really excited about that. Because what the West people do is great and it's helpful for finding cases, but I don't really care so much what they think about a case, but I really care what Chris thinks about a case. Because I know Chris. I know his analysis is going to be top notch. And like the secondary sources, it's people who are authorities on different topics who are writing things. And so Chris is a law professor. He's a law professor at Moritz College at The Ohio State University. And even though Ohio State did not make it to the Final Four, I think that we'll all be really happy when we can kind of get beyond this duopoly and we'll be dancing in the streets with Pablo's company and companies like that. Make human curated content available in an open access model. I'm really very excited about that. So turn over to Pablo to tell you how that's going to work.
Thank you. Are there any questions for Paul still?
I'll stay.
All right, Paul. Jim, you gonna?
Yeah, well, I'd like to show the. All right, well, hi everybody, I'm Pablo Arredondo. I'm a fellow at the Stanford Center for Legal Informatics and vice president at CaseText, a startup. I'm really impressed to see people here that are getting an understanding that informatics is going to play a huge role in your profession before you graduate. I had a much more superficial path in the sense that I was there working in Kirkland as an associate, and I sort of had this daydream. We're representing Apple in a patent case, and I had this daydream that somehow Steve Jobs was going to walk by and check in on the associates on his patent case. So I thought, well, I better get a Mac because he'll be Mac. I don't have to. So I buy a Mac, and it was 2005. That beautiful one at first iMac, And so now I'm in this mind frame where I'm comparing the sort of Jobsy and everything to what I was dealing with Westlaw and Microsoft, where all of these technology that we're using. So I was really annoyed, right? And so that was my initial drive, very selfish, right? Just what about me not being annoyed? But as I started looking into this, I realized there's actually so much more at stake in the tools that we're using, right? If the software doesn't work well, if students are only looking at the first 7 cases that are returned, lawyers are only looking at the first 7 cases that are returned, then you're missing cases, right? So the entire quality of our adversarial system falls. And then there was a whole other level, which is the fact that, at Kirkland, we didn't worry about our Westlaw case, to be honest. Maybe things have changed now, but in 2005, 2006, let's go nuts was the strategy there. But I came to realize that that is a very small portion of the profession that gets to look at it that way. And Paul has told me horror stories about attorneys that are forced to go to the public library and they get 20 minutes to shepherdize a case, and then they're done. And you can't do what you need to do in 20 minutes. And so if we have an adversarial system and we purport to have equal access under law, if one side doesn't have the same ammunition or the same weapons than the other, clearly something's missing. And so all of this, I think, best for me, combining both my sort of I don't want things to be annoying, my sense that we can't be missing cases, we really need to have the most sophisticated tools we can, and the fact that we need a system that's free so that we can actually have equal access. It all really came to a head when I was introduced to Case Text, founded by a fellow alum, Jay Keller, who Paul put me in touch with. In a sense, if you think about it, what is the opposite of duopoly, right? It's a crowd, right? I mean, how can we make things as un-Westlaw as possible? Well, instead of having one system with one regimented framework that they put on, let's open it up to experts. Let's let the different communities who understand their domain and have passion for what they're doing, let them impact the analysis and input the analysis and the functions. So it's relatively early days, but this is where we're getting started. So let's see, let's start with time. So I want to start first just by talking about what it means when you can crowdsource functionality, right? So there's a librarian at the University of Nebraska named Richard Leiter who had an idea about, we have that huge, you saw that long list of books of all the cases, right? Millions and millions of opinions. He said, well, what if we could filter down when you search to just cases that have appeared in a law review article, right? Because law review articles, there's somebody who cares about conveying only those cases that have some substance to it, right? So based on that idea, then, we're able to actually create that filter relatively straightforward, in a straightforward manner. So if I do a search for patent here, you see 46,000 cases. This leading cases filter here brings it down to 1654, right? So you're dropping 2 orders of magnitude just by applying this one filter. Now, I think that if you look at across our profession, including very much the advanced legal research faculty, there are tons of ideas like these that need to be implemented, and that can be implemented when you have a crowdsourced system. And I think that is one of the most exciting things to me is that it's not just going to be analysis that you can find, although that itself is going to be huge, and I'll get into that in a second. You actually can start changing the filters and the functions that you have in crowdsourcing. So part of, I think, what is driving Case Text, right, is how do we make our professions more efficient, right? So you have right now law firms that spend a lot of time writing up summaries of cases so that they can impress potential clients, right? They want to show the GC of IBM, look how on top of this thing. Why don't we leverage those summaries, put them directly into the legal research database, right? They've already created it, why don't we just add it? So Bingham is an example of a firm that we kind of raised this to, and they said, sure, take them all, right? So now, when you're researching a case, where Westlaw had, that sort of summary by an unnamed editor that you don't know who it is, you get analysis from a law firm, and you can click on the attorney's name and see who it is, right? So it's leaving the system where everything was created behind a closed door that you didn't quite understand, and frankly, even the advanced legal research faculty only were given a small view of it, right? To a system now where you know what you're getting from who and how, right? That's another example of the things that you can do when you crowdsource. One of the key things, though, so this one has no research. One of the reasons, though, we're never going to be able to take down a duopoly of Westlaw and Lexus truly until we have a citator. And actually, this ties into the project that we've made available to you guys. Citator, you guys mostly know, right? You don't want a case to be overturned, right? You don't want to rely on bad law. But even beyond, more subtle, you don't want, you want to know how subsequent cases are treated. So actually, it's interesting because 200 years ago, there was an attorney named Simon Greenleaf who relied on a case that had been overturned. He got embarrassed in court. He went home. He lived in this really small town of Maine, and he's like, that was horrible. I'm going to start writing down every case that I know that's been overturned. That was the beginning of the citator. This was back at a time when the Supreme Court used to ride around in carriages to different towns and they roll up. And a Supreme Court justice came and was basically, I'm paraphrasing here a little bit, but hey, Simon, what are you doing? Oh, I'm writing down all the overturned cases. That way I won't do that again. And he said, you know, that's a great idea. I got a list too that I've been making for a few. Why don't we put them together? We have a big list, right? And then he said, you know, what we should do is publicize this. Maybe all the gentlemen of the bar will participate. So there goes the patent on crowdsourcing a citator, right? Because this idea is not one that depends on technology, right? It's just a simple understanding that if multiple hands put in a little part, you can create something magnificent, right? So what we've been doing, again, in part of sort of, how do we make it efficient? How do we not waste energy and time? Well, law students need to learn about citators, right? That's something that you learn in advanced legal research classes. But what better way to actually learn the nuances of citators than to actually get your hands dirty and create a citator entry yourself, right? Sort of be your own shepherd for a day, right? And so what we did is we said, well, with a tool like CaseText, you can give the students specific citation relationships and say, you guys tell us what you think it is. And this is the result, for instance, from Nebraska, right? You see they're longer, right? They have actual full descriptions of how cases impact each other. And I think you're going to get trade-offs here, right? So on one hand, it takes longer to read something like this, right, than to just see a flag that says distinguished, right? On the other hand, you have a much better chance of grasping the nuanced situation and actually knowing what's going on, right? What does Lexus and Westlaw give you underneath the case when you shepherdize? They give you that random snippet of text where your case appears, with like just a random number of words before and after, as though that's going to convey to you what's going on, right? You almost invariably have to go read the case to have any semblance of what's going on. And I think the sad fact is that most people just don't do that after a certain number, right? So you, again, it's the quality of the adversarial system that we have is a play there. So this is something then that, along with the advanced legal research class, we've also created a system. So this is casetext.com/resite. You know what, actually I think it'll be easier to show you that later. But we've created basically a module that will let you create a citation entry and click next and go to sort of the next one, right? So we've made it basically easy to sort of do this in a systematic way. It's similar to a sort of Wikipedia effort in that regard, in which you're counting on people that just care about certain areas. We've had nonprofits like in animal rights and animal defense come and say, well, can we have a big annotation party, right, where we're going to annotate all of our cases. And I think that that's another key area, right? You have people that are passionate about a certain area of law. They want to help each other. They want to create that same sort of dynamic that a law firm has naturally, which is that they're sort of joining their intelligence and their forces. So that's another area that I think could be very productive. So those are just some of the potential of a crowd-based system. And you know, it is a crowd-based system. We know that there are going to be others that we don't think of. And so the community of people that use us and that can submit ideas, or that we get to talk to about this is very important. And to that end, perhaps I know 25% of your grade is participation, so why don't I let you guys rack up all those points right now. With the last few minutes we have, I mean, do you guys have ideas about ways that we could, you know, use a crowd-based system?
I was curious, do you have some sort of verification system or reputation-based system to check the quality of the application?
Right, so absolutely, and this is something we borrowed from like Stack Overflow, etc. If you click on a certain, so let's see this professor. So, you know, as Paul mentioned, you know, one of the best ways to verify is you sort of build a guy, you know, his institution. We're also setting up a system where you get reputation points, which can be based on whether your analysis has been upvoted or downvoted, how much you contributed.
What about keeping it evergreen? You know, I mean, when another citation comes along, is there some way you could be following that you've got a connection between two cases? What happens when the next case comes along?
Right, right. So yeah, a citator is only as good as how frequently and well it updates, right? And so that's part of the reason why we want to get this established in advanced legal research classes, because there's a fresh group every time, right? There's a fresh wave that comes in needing to do it. Another thing we're trying, we haven't really implemented this yet, though we're looking at it, is law review tryouts, right? Right now, to try it out for a journal, you got to do this whole song and dance. And my thinking is, if you're going to make them dance, put grapes underneath, squish out the wine, right? And, you know, and of course, it matters well who's the quality control on this. And so we've been fortunate that the people who have the best understanding of legal research, again, the advanced legal research faculty, they're sort of on board with this. They like the idea of moving past the duopoly, and they understand that they're best suited to actually do quality control. So again, you have this image of the students just kind of smashing about, and then we create an oversight mechanism, sort of like Wikipedia has, to moderate, to see, if things are wrong. Please.
So I saw when you did the searches, you had a couple of different labels. How do you generate those labels? Is that something like what you were saying, is people crowdsourcing, oh, I thought this case was about intellectual property. And then how, if I go to a case, can I say, I agree, I read this case, I also thought it was about intellectual property, maybe strengthening the label that's attached to the case.
So right there, add tag is how you add metadata. Anyone can do it. Now, we don't have an upvoting or downvoting on the tagging system, although that's something we need to think about, I think. And not only can you add it to the case, you can also add it to specific paragraphs. And this can be useful. So one of my early research assignments was in a patent litigation, there's something called a patent claim, which is just the part of the patent that you're actually fighting over. And you have a Markman hearing where you construe each of those little words. What does it really mean to say computer? How do we really define that? So they said, the patent claim said at least one of X and Y. And they were like, go find a case where they construe that. And I'm like, if my search query is at least one of, like how am I going to, right? You can't put variables into the system. With a system like this though, you can, it'll actually work. Like I started doing it just to show it. Patent claim, right? So you can now go to just the cases, and this was actually the one super guide. You can say, I just want the cases where the term is in the actual paragraph that is tagged patent claim, right? So you can now search in a much more nuanced way. And when I think of all the ones that I can think of for patents, all the subtle ways that you can make it better, I imagine each domain is going to have that, right? So with respect to Westlaw's big book, what they did with everything, there's no way they're going to be better than the people who actually live and work and do this work, right? There's no way they're going to keep up.
Another option is curating sort of research question chain. So I work in immigration law, and you're dealing with, say, an asylum case that deals with a particular social group. There's going to be 20 cases that everyone needs to come back to hit the major elements of their argument, and then they're going to dig from there. And there's a way to say, like, here's some master questions, almost like a secondary source.
Absolutely.
That we've curated with a few little summaries or annotations that we've clustered, and then you can start there and then start digging in.
I mean, this has worked so well in computer science with a site called Stack Overflow that I'm sure the developers here understand. You start with a question. I actually tried to do a little coding myself, and every crazy question I could have, somebody had already asked it, often apologetically, like, I'm sorry guys, but, can somebody explain this? And it works amazingly well. So I think that that's great.
One of the challenges, particularly for patent law, would be diagrams. So have you thought about how you might search for those in, say, patent claims?
So for actual images. Well, our engineers here might be, this is what reticulating spines is about? One of our engineers did medical imaging, so he might speak to that.
Sorry, what was the question again?
Well, have you thought about, the research challenge of annotating diagrams, searching for diagrams?
I would say that it's not something that we have started to address yet, but it's certainly something that might come up down the line. None of what we have in the system yet involves any image data, but as as we grow and evolve, plenty of these opinions, when they're published in print, they have image data and diagrams. There's no reason why that can't be folded in, and then you can progress to allowing that also to be.
Professor?
So I'm sorry, I missed some basic point, which is where are the cases coming from? Not the commentaries, but the cases themselves, and how do we, because we can get those from Lexus and Westlaw.
So currently we are purchasing case law from a third-party vendor. Anyone who gets into the area of getting case law, it's a very shady world somehow. Even though it's case law, it's very like that. So we're not allowed to say, nor is Google actually, information should be free, that's their motto. I'm like, where do you get your case law? Not that information, that's so right now from a third vendor. I think the work of core listener and obviously Brian Carver from Berkeley came and spoke here. They're now a nonprofit that's working on scraping the courts directly and getting the case law to come. Now it doesn't come in a very pretty format. And fortunately it's not my job to have to deal with that. Mr. Data, those gentlemen over there, I'm so lucky.
And a company called Fastcase. There's a company called Fastcase. It's a kind of there's these big expensive databases at Lexus and Westlaw. There's also a number of lower cost services. But Fastcase, what they do is they buy the official reports and they have them double keyed. They actually to have two people type each case. And the reason for that is because it's not official until it's in this. So the opinion put on the website may differ from what's going to be in this book. So they get the cases. Fast case, you getting cases from Fast Case?
I'm not at liberty to
So,
say.
okay, but.
That sound like a good company.
It is a good company. And we have an account if you want to explore Fast Case. But they send these off overseas, and somebody in some foreign country who had a typewriter or a computer just types these in. And that's how they get them.
And how does the coverage that they provide compare to the coverage that Westlaw or Lexus provides in terms of the number of the cases?
Very similar.
Is it
Yeah.
very close?
The only slight delay because they have to wait and get this
Yeah.
done. But it seems too bad that they can't just take it from the websites. They have to wait for it.
So I'll leave you with another big obstacle that any startup faces, and that's something Bob Baring at Berkeley calls the Tinkerbell effect, right? There's this Tinkerbell, this fairy that only exists because everyone thinks she's real. And as long as nobody questions that, then she's fine. That is his analogy for what Westlaw is, right? We all sort of think that this is the best system, that this works fine. It's all, it's our grandfather's system. In fact, anyone who actually takes a look at it and actually does systematic comparison, for instance, other shepherdization versus Keysight, finds, well, they don't agree with each other, they can't both be right? And there are flaws there. I think the work of Susan Neverlade-Mart, if I can throw some optional reading at you guys, she really gets into the statistics of that. And so, Tinkerbell must die.
Once I get my teeth into something, I hate to let it go. So what I'm trying to figure out is there an opportunity here for some technology to make case information available more easily to everybody by maybe moving upstream to the courts directly and so forth? Is this already via these various different black art?
Yeah, right now it's the black art. You're reading guys under the underpass, so give you just a little bit of case law. But there's a couple things that are rated. So I think Oklahoma, for the first time, has said our electronic version that we post is going to be our official version. So that problem right there. If somebody can figure out on the technical side how to go from that PDF that they put up and send it. I once actually called the court and said, "Do you guys mind sending me that in a different format?" And he went away for like 20 minutes, and then he came back and said no.
So Larry, our former dean, was very keen on seeing this problem solved. Now, was he off base, or was he actually on the mark in terms of there being a technological problem with the business and legal opportunity?
Fantastic opportunity. The ability to go from the sort of raw output. Now, I think the ultimate system, at some point the judiciary is going to have to come to the table, right? At some point we're going to have to be like, guys, you can't keep being terrible too, right? Because it's making it harder for everybody else. But until that day happens, there's certainly a lot of room for people that can take the raw output from the courts and put it into machine-readable formats, parse it for things that are important.
Can you maybe also explain the role of Pacer in this ecosystem?
Pacer, there's another one. Okay, Pacer. Pacer is the system that the federal government has put up, the god-awful, unholy interface system that the government has put up, where if you're working on a case, you get an email from Pacer saying, hey, the judge has filed an order, right? And so if you're the attorney, you can go there and click it. Otherwise, now you get one free click, right? Pacer charges 10 cents a page. I believe, or is it 15 now?
Yeah,
10 cents a page. I don't know what CIA black fund this thing is funding because they are not putting that much money into the actual design of the thing. There's fortunately a company called Pacer Pro that's now built a shell that you can put on top of Pacer to try to make it less unholy. But Pacer, yeah, I mean, you can get all sorts of raw data from Pacer. It's similar to sort of the raw stuff you get from the courts. The late Aaron Schwartz, he had taken advantage of like a weekend loophole. They said, we're going to take down the paywall. Oh, don't give Aaron Schwartz a weekend without the paywall, because we got every library to download, a huge amount of stuff, and that became one of the big public free archives. Any other good things?
Do you have any, or anticipate any transactional resources, or just primarily?
Yeah, so this company was incubated at Y Combinator, which is the one of the incubators for startups, and they released a new default equity agreement that they called the SAFE agreement. And we put that up, and it was really cool to see entrepreneurs, transactional lawyers, the investors, everyone sort of commenting on it. Because I know litigation so much, I don't know much about transactional law. I've heard it's big, I've heard it happens. I've heard there's whole departments even that do it. And of course, I think that there's a lot of room for this sort of approach in transactional. Please.
Have you guys had any experience with bad actors so far? So obviously there's
I mean, so Wikipedia even has the chicken article that, despite all their best efforts,
all right,
yeah.
So bad, I mean, when you get into like mental illness, is that bad? I don't know, you know, not adding quality analysis, right? So we've had a couple guys, they tend to be in the district court, who are trying to relitigate the case, making very wild accusations about various people and things like that. And right now it's just sort of like, they're there, man. I mean, those comments won't be upvoted, right? We haven't come across somebody like deliberately trying to say something wrong, right, or something like that, like a saboteur. But we have definitely seen our group of sort of, hey, dude, are you okay? Like, it's not really helpful analysis to yell at the cops like that, but all right, then, all right. So, yeah, that's an issue. As the community gets bigger, I think we'll have more mechanisms.
Yeah, just piggybacking on that, I was going to ask, so you mentioned that there's a reputation, like a nascent reputation system in place for commentators. Are you thinking about maybe including something like that for participants and contributors, or also like any ways of possibly like gamifying the platform?
So gamifying something is definitely on our minds right now, and it's something, yes, we want to do, and we want to create sort of incentives and badges and things like that that have actually worked really well in other systems. Absolutely, we want to have the reputation for all contributors, because one of the ways that this can be very useful for students and attorneys is you can brand yourself a bit, right? So if you want to be in satellite law, you go and you do the citations for the satellite cases. He Googles your name, as long as your name isn't Mike Smith, you're going to see, hey, look at all the work he did on case study. You know, Stack Overflow, the computer science one, has gotten to a point where instead of a resume, you can say, go look at what I've done on Stack Overflow, right? That's where, if we can get there, I think, and I think we can, it'll be add a whole nother force of energy.
You kind of talked about it a little bit, but I just was curious to clarify. So are you looking to set up some type of system where someone could log in and say, I have this really specific question and I'm just going to throw it out there, kind of like Stack Overflow? Because you can imagine over time building out a system where if I did Google it.
That system was actually built very early on, and we called some law schools. And it was sort of one of these things like, so any lawyer submits a question and our law students do the research for free. And I was like, yeah, exactly. Isn't it great? Like, it's great to click, you know. So we, you know, part of this process is you're iterating how you approach things, how you understand things. So yes, that has been built. It will be part of the system at some point. And I think that what you describe about, immigration attorneys will have like a listserv where they have very informed conversations and really use that as a resource. We can sort of take that times a million because we can tie it to the actual legal search engine, have links directly into the questions and answers. So, but yes.
Are you working with any firms other than Bingham?
The other firm than Bingham, there is one other one, and I'm blanking on his name right now. There's two so far that have sort of said yes. Oh my God, how can I blank on it? Wachtel is the other firm. We haven't gotten that spread as much as we can, but we're definitely working on it. We also realize that the firms have a blind spot. Like the firms are not trying to impress certain segments of the community. They're trying to impress Fortune 50 companies, right? So the next role I think would be leading blogs that cover areas that are less dealt with by the firm.
So this is a company that took private money.
Yes.
So it has to be profitable.
Yeah.
And how do you make money?
Okay, good. Well, so first, I think inherent in that is the question of what assurances do we have that you're not going to take all of this and use our content to make money, right? And there is that this is all public domain under a Creative Commons license, so we don't own it even if we wanted to. And for the we site especially, for those citation entries, we're creating an API, so those will beam out to everybody. In terms of our actual business model down the line, you can imagine some of the functionality here being useful internally for a firm, right? So you can see Cravath saying, oh, over the last 80 years, we've curated the perfect law database, and Wachtel doesn't have it, and we do, right? So you can sort of imagine a private version of that. I think that would be wonderful.
So knowledge management for lawyers.
Right, knowledge management, but also adding in functionality that they can create. I think that it's important. I think one of the coolest things about this is going beyond just analysis, but also how does it function? What are the filters? What are the keywords that you can use and things like that?
And so you're also, my other question, so you're also putting a lot of case law on the web that's currently kind of behind the paywalls, behind Lexus, Westlaw's paywalls. And presumably there's a lot of personal information in some of the cases too. So it is already public information, right? But now it's much more accessible online. Have you got any complaints by people who are now Googleable?
We get requests saying, please would you take this down, it's putting me at risk, right?
And how do you have,
Our
did you develop a
current,
process to
current
build
process, and honestly, this is something I think we need to think about more. Our current things will say, look, we'll tell Google not to index it. So if somebody Googles your name randomly, then they won't see this as a list. But we can't take a case out of the database. I'm sorry, you can't like say, I wish that part of the law. And sometimes it's like, dude, yeah, you lost a terrible lawsuit. It was horrible. You shouldn't have brought it, that suit. You know, I'm leaving it. As an people can use that to do a brief about how you shouldn't have filed lawsuits like that. Some are more sensitive, actually. So right now, we'll accommodate you by the Google index and then leave it in it.
Are there any other questions for Paul?
Oh, I was wondering if you had, do you have any like kind of system of secondary sources at all, or is it just mainly the cases?
Right. Right now, it is just the cases, and of course, the secondary analysis, in a sense, is the analysis that you get added on. So we're sort of liken it to the Talmud, where you have Rashi's commentaries directly there. There are some companies that have talked to us about secondary materials and adding those, but frankly, from the literature I've read, a lot of your articles aren't getting read anymore by anybody. And I think that there might be something to putting analysis directly onto the search engine that the attorneys are using while they practice. Right. All right, guys. Well, thank you so much. It's been a real pleasure to get to. Jake, our CEO, is Jake at casetext.com. Please do not hesitate to write us with questions, ideas, complaints, anything you guys want.
You have jobs.
Yeah, we've got some jobs lined up.
Are you hiring?
Yeah, the right people. Okay. Clearly, only the best.
I think that's all.
That's good.
Are there any additional questions maybe for Paul? No? Everything clear? All your questions about legal research technology have been answered.
Case text, the end of the
That's the end. First semester.
So since I'm not a member of the law school, maybe Paul can say a little bit about what does the law school, tools does the law school provide to Stanford law, to Stanford, and since there are others who are not in law school, what tools are provided for free because we're here?
Right, yeah, there should be no problem to get Lexus or Westlaw passwords for you who are not law students who want them. Since you're taking a law school class, you can just let me know, just send me an email, or you can send an email to reference at law, Stanford.edu, or stop by the library, and then we'll put you in touch with our vendors. They have in the past always issued a password for taking a law class, so that shouldn't be a problem at all.
And then you can scrape the entire database.
Bloomberg too. Bloomberg is one of the upstarts now that is trying to, give some competition to Lexus and Westlaw. They only have Boolean searching at this stage, but they do have Pacer. Pablo mentioned Pacer. All of Pacer is available to you through Bloomberg, and Pacer is federal court dockets, public access to records, electronic records. But it also, Bloomberg also has state dockets, some state dockets, actually quite a few state dockets. So you might want to stop by the reference desk in the library and just ask for an account for Bloomberg as well.
Great, thank you. Okay, so yeah.
I'm just wondering, Sir Paul mentioned a lot of calling a bunch of research librarians. Do you get contacted often about new research methodologies, or what type of startups are there?
Yeah, actually it's been a steady stream in my office, and it's kind of interesting to see what people are doing. This one really is really exciting though, and the librarians who Pablo is working with are really enthused about it too. So we tend to be kind of a skeptical lot, but they really see value to what he's doing. Yeah, I think he's on something here.
That's great, that's great. Okay, so a couple of other, any more questions? No more questions. Professor
Pablo, can everybody access case text?
Well, of course, that's the whole point. It's
Okay.
100% free.
It's on our website.
To annotate, you do have to create a user profile. That's the only thing, but that's completely free, no subscription, nothing.
I mean, I just think it would be nice if any of the tools we talk about here in the course, to the extent that they can be made available to everybody.
You can make it your homepage that you sign on just automatically when you open your browser.
For Pablo, you said before you left stand about the fact that you said people are not reading the secondary. I wonder, based on this, can you use take out statistics-wise, well-cited paragraph, well-cited pages, and then simply put them online, and that will be allowed people, instead of rating the entire round versus Board of Education, read the best highlighted paragraph, best highlighted pages, secondary articles that are, the pages in the secondary articles that are much more references.
So right now, that's first of all a great idea and point, and so great that we have a system sort of doing that right now. We have a heat map that's on the side. If you look at a case, you'll see that there's different shades of red. The most red is the part of the case that has been cited the most by other opinions, right? So, you know, in law school, you're used to getting cases that have had all the weird stuff, not weird stuff, but just the boring stuff cut out, and you're just reading the meat. Most cases, unfortunately, are not like that, right? So we have a system now that will let you quickly get to that part. I think it's an interesting idea to have a button that just says, don't even bother showing me the rest, right?
You might mention that the citing, case of citing, you know, citing, where the case is citing and really is the earlier case. Or,
right.
You want to mention that? Or?
Oh, you mean the inline citator?
Yes.
Okay. So do you mind if, I mean, sure. So another system, again, trying to make it as easy as possible to create the all too critical citation citator entries is our inline citator. So if you're reading a case and you're like da 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 da, and now it might make us sign into this. You're reading a case and you're like da 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 da. See, this is what I mean when I say all these facts. Then you see, okay, how is this case? Well, actually, that's such a bad example because it's the same case. Let me just go down a little bit. So you see that this case now is citing to Rain and Shaw PLC, right? And let's say you're like, you know what, this is important to make a note. Like this case is either returning it or is doing something impactful. Without leaving the case that you're reading, you can click this button, which will then allow you to create a citator entry that will automatically be appended to that other case, right? So now, if you create this for Wren and Shaw while you're going along, subsequent users who shepherdize Wren and Shaw will see your analysis there. So that's another way to create what we call recites. You get a key site, it's a recite. That was Susan Vanderbilt's idea that we run with. And again, it's key to think, you know, we have 4 categories, but really it's the text box. This is the thing that you can use to capture nuance, to really describe the relationship, right? It's the text box that you can blow the flag system out of the water with. And I, highly recommend you guys do it. We have a special scoring system for recites if you create them. And we'll be, again, gamifying it. I think that's part of our process. So, okay. That's
So there seems to be a trend to the we combinations there. I recently came across a legal tech company called We Wars. So anyway, so okay, Pablo, any 2 quick final questions? Is there a plan to do this internationally, or is this just focused on?
Yes. First, we take Manhattan. Tomorrow's Berlin. Absolutely. And in fact, we've had people mention to us that we'd love to have this for various international content. And if you guys have anything that you're interested, let us know, and we can work on getting that content out.
Okay. Any general words? So you're a serial legal tech entrepreneur. So,
I guess does two make you a serial?
That makes you.
All right.
Any kind of words of wisdom?
Oh, for being an entrepreneur? Well, it's a ride. They say the highs are high and the lows are low, and I think that I might say that that's true, but also you're in both high and low at the same time constantly. So that can be stressful, but it's something so cool about building something where there's nothing. And I think litigators, we have a sort of a rap maybe, especially in the IP right now in patent litigation, and maybe we're taking more than we're giving in terms of value. And to switch from that to something where you feel like you're actually building something, I got to tell you, it's an amazing feeling. So I would say do it.
Great. Well, thank you so much, Pablo. Okay, so first of all, did everyone sign up on the sheet? So please sign up. Also, next week we will have. Well, first let's talk about the legal technology project. So, as I said at the beginning, we have 8 projects that were proposed by Friends of Codex, and they range from Pablo's recite system to questions surrounding unbundling of legal services, to questions whether sort of wills and trust practice can be made computable, to e-discovery in social media, to let's see, creating a legal comments. So a bunch of different interesting legal research problems. And so even if you are going to be working on your own legal technology project, it's worth kind of checking out the projects that were proposed by these companies. So I think it's instructive just to see what these companies have on their minds. So that's the first thing I wanted to mention. Next week we'll be still talking about legal document management. Next week we'll be talking about the data-driven legal practice, and we have leading scholar Professor Dan Katz from Michigan State University School of Law come out here. So he's really known as the preeminent thinker on sort of big data and the legal profession. And we're pairing him up with Josh Becker, who's the CEO of Lex Machina. Anyone knows a little bit about Lex Machina? Phil?
I worked there last year.
You worked at that, okay. So Lex Machina is really the first spin out from Stanford Law School. It was based on Professor Lemley's idea to create a big database on all IP litigation that's going on in the country, and so that we can get empirical data about what's going on in the IP system. And so that was Professor Lemley's. He's an empirical patent scholar, the patent scholar in the country. And so we created this. This was initially called the Intellectual Property Litigation Clearinghouse, and it was built by folks from Codex, and kind of created here at Stanford. And then we found there's commercial viability, and so it was spun out. It became a company, and it's doing really well. And their tagline is sort of Moneyball for the law. So their service is like creating really sort of deep analysis on IP cases that all the stakeholders in the IP system can use. You figure out if if you're a large company and a patent troll comes after you, you can sort of optimize your strategy based on some of the information you can get out of this very cool database. So we'll have Professor Dan Katz come, and Josh Becker, the CEO. He's actually giving us all access to the database, and I'll be sending out an email with sort of a link where you just have to sort of add your name, and then you get access to Lex Machina. And I'll be also sending out sort of a number of questions, which is kind of the homework for next week, where you can then try to find answers to the question using Lex Machina. So I can get the email addresses of all the students who've signed up for the class and coursework. But if you haven't done that, perhaps you could just, and you want to get access to Lex Machina, perhaps you could just, write down your email address so that I can send you the link where you can sign up for Lex Machina. So,
as I mentioned earlier, I think it'd be valuable if we could put on the website a list of all the technologies that are available to us around the corner. So we can
sure.
buy Lexus, case specs,
Yeah.
Lex Machina and so forth. We'll just have links and you can click on any of
Right.
those that we've made available.
Right.
So we'll create something like that as well, I suppose.
Yeah, sure. Sure, absolutely. I think law students have already access to Lex Machina through the library, I think. But I'll send out that email. So, did everyone sign up on that sign-up sheet? Okay, great.
I haven't signed up.
You have? Okay, so please sign up, and I'll let it go around again. So if anyone who's not signed up for the course, who wants to leave his email address, so I can send them information.
So this is the library's website, and then you can just search legal databases, and this is the list of all the databases that we have, that you can have access to as well. So you need any help or need any help with these, getting access to these, you can stop by and see us.
This requires Stanford login, or is it?
Some require password, some are IP, some, it varies. So again, just contact us if you have any problems with any of them.
Okay. Did you have another question? Jerry, you had? Oh, you just want to sign up, okay. Okay, any final questions? We're finishing a little bit early. Normally we'll take actually like a 10-minute break sort of halfway through, but today we just, just kept going. So, there are no more questions. I look forward to seeing you next week. Same time here.